In today's courts, judges rarely try and adjudicate cases. Professor Mark Galanter famously termed this trend the vanishing trial phenomenon. What then is judges' role in civil litigation? A rich body of literature tells us that judges' role has gravitated considerably from final adjudication of facts and law to case management and settlement promotion. We conducted an empirical study of Israeli civil trial court cases in order to measure the scope and nature of judges' role in civil litigation and shed light on its relationship to the vanishing trial phenomenon and the settlement culture in courts. In an era of scarce trials, frequent settlements, and considerable litigation abandonment, looking at the variety of procedural roles that judges play in litigation is particularly important. That is because, through their various forms of involvement in litigation, judges can scrutinize the proceedings, influence litigants' behavior and decisions, and shape the outcome. Therefore, access to judicial involvement in the case becomes an important dimension of access to justice, especially for self-represented litigants. To examine these issues empirically, we introduced the concept of judicial procedural involvement in litigation, JPI, and explored its manifestation in a representative sample of 1,283 civil cases that concluded in Hashalom trial courts in Israel between the years 2008 and 2011. We distinguish between cases that were exposed to JPI, that is, judicial procedural action throughout the litigation process, and cases that were exposed only to the institutional function of courts. We measured 3 types of JPI. First, ruling on motions during the filing and defense pleading phases. Second, conducting pre-trial hearings. And third, presiding over trials. In contrast, the court's institutional function refers to cases that terminate without any JPI. So, what did we find? 40% of the cases in our sample terminated without any JPI, meaning that the cases disposed before a hearing took place and with one or no motions being filed. Of the 60% of cases that were exposed to JPI, 26% disposed after the judge ruled on at least 2 motions during the filing and pleading phases, 22% disposed following at least 1 pre-trial hearing, and 12% of the cases involved at least 1 trial hearing. Next, we explored the relationship between the type of judicial involvement in the case and its mode of disposition. The figure shown here describes our finding, alluding to the potential scope of influence of judges on litigants' behavior and decisions. One notable finding is that 65% of the settlements preceded by JPI, indicating the potential scope of direct judicial influence on litigation-related settlements. Treating judicial procedural involvement as a resource, our analysis suggests that access to different forms of JPI could be a useful additional measure of access to justice and procedural justice, especially when considering differences in access to judicial involvement between different types of litigants, disputes, legal issues, and so on. Finally, policymakers can use the JPI framework as an organizing principle for procedural reform by identifying areas where it may be desirable to encourage more, less, or different allocation of judicial involvement in litigation. For example, it can be used to identify case categories that are likely to be appropriately handled through alternative dispute resolution or through online court proceedings.